Hello friends, here we have to come for the discussing about Indian Contract Act 1872. Here we have to, I think, know that Indian Contract Act 1872 has been an topic of business law CF Foundation paper 2 business law chapter 1 Indian Contract Act 1872. Here we have to first of all complete unit 1 in this lecture. Introduction part. Indian Contract Act 1872 has been introduced by not by Indian, rather than it has been introduced by Britishers in India in 1872. It is applicable to whole of India, but excluding Jammu and Kashmir. That is, in Jammu and Kashmir, Indian Contract Act 1872 has not been applicable. Second part, we have to know that contract has made with two things. First, agreement. Second, enforceable by law. Agreement has made also in different types. Here you have to know that business agreement or social agreement, or you can say I think you have to remember that social, you have to remember that immoral agreement. There are many types of agreement, but in the eyes of law, agreement in such case, agreement only business agreement, that is which is enforceable by law, has been made in contract. Agreement has been defined under section 2 subsection E of the Indian Contract Act 1872. Agreement means every promise and every set of promise forming the consideration for each other is an agreement. That is, every promise and a set of promises forming the consideration for each other is an agreement. All contracts are agreement, but all agreement are not contract, because that when we have to talk about agreement, then there are certain agreement which are not enforceable by law, that is, it is not valid in the eyes of Indian Penal Code, therefore it cannot become a contract. But when we have talked about contract, there in such case every contract must be enforceable by law, because that only such agreement become a contract which is enforceable by law. Therefore every contract is enforceable by law, and every contract has made with the help of agreement. Therefore we can say that with the concluding and statement, we can say that every agreement is not a contract, but every contract is an agreement. Offer has been defined in the section 2 subsection A of the Indian Contract Act 1872. Definition: when one person signifies to another his willingness means इच्छा, to do, कुछ करने को, to or abstain from doing anything, कुछ करने को और कुछ नहीं करने को, समझे, with a view to obtaining the assent of another. That is, when we have signified on willingness to another person with an intention to view something, that is, we have not an intention to funny like joking. Here we have to intention to do to view to obtain an assent, that is, here we have to intention to take an assent, that is, take an consent on that offer, or an act or absence is known as offer. And again we have to listen: when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of another, such an act or abstinence is known as offer. Characteristics of offer. There are certain essentials of a offer, that is characteristics, or institute can also ask you with you what is the essential of a valid offer. Here, and when the institute uh, has has asked with you what is the essential of a valid offer, then you have to listen that essentials means a characteristics and essentials both are same to same. Understand? Offer must be capable of creating legal relationship, that is an offer must be capable of creating legal relationship, that is if the offer has not been capable of creating legal relationship, then it can not be comprised as a valid offer, and it is not valid in the eyes of law, therefore it will not treated as valid offer. In the leading case law, Balfour versus Balfour, here Balfour, a man, and Balfour, his wife. Here Balfour, being as an husband of Balfour, has promised to gift a diamond ring on the 16th birthday to his wife, but on the birthday he fails to fulfill their promise. Therefore therefore she has no right to claim against Balfour, because that it is not capable of creating legal relationship in the eyes of Indian Penal Code. Therefore they cannot suit against each other. Therefore an offer must be capable of creating legal relationship. The term of the offer must be definite and certain, that is the offer must be certain. Anything which is not certain, that is anything which is uncertain, is not a valid offer. That is, if we talk about, we have required 5 kg of oil, and here there is no mention what kind of oil we have required, then in such case it is not certain offer, it is an uncertain offer. Offer must be different from invitation to offer, that is in the eyes of Indian Court of Law, offer is different from invitation to offer. That is when we have to see in any display of price, there is only an invitation to offer which has been given by shopkeeper, and when we have to agree to buy such an things, then there is an offer, and it can be accepted or either it can be rejected by the shopkeeper. It's depend upon the willingness of the shopkeeper. He either can reject the offer or he either can accept the offer. Therefore no one can suit against shopkeeper for the rejection of the offer. Therefore offer must be different from invitation to offer. Offer should be communicated. Therefore to conclude a valid contract, we have to must be communicated to the offer to the offeree. Therefore that is when offerer has expressed their willingness to do or not to do something on a certain things, on a certain consideration, then such offer must be communicated to the offeree to whom the offerer has given the offer. If the offeree has not come to knowledge about the offer, then there in such case offer will not be treated as a valid offer. Offer can be expressed or implied, that is an offer can be expressed or implied, that is offer either you can give an offer in a express manner, or you can either give an offer in implied manner. That is If you have to give an offer on a written manner or orally, then in such case it is an express offer. Or either you can say that when you have to go to the ATM and withdraw money from the ATM or from another ATM, or with the same ATM or with the respective bank, there in such case it is an implied offer. That is, there is no expressly written communication has made between offer or offeree. Therefore we can say that it is an implied offer. Offer can be conditional. That is, an offerer can give a offer to the offeree with an condition. That is, if the offeree has fulfilled that condition, then only in such case offer will be treated as a valid. Otherwise it cannot be treated as a valid offer. It can be a conditional. It is depend upon offerer. Offer should not contain a term non-compliance of would which would directly lead to acceptance. That is, offer should not contain a non-compliance. That is, no one can say that if you can not give an acceptance within a 5 days, within a certain time, within a specified time, then I deem that you accept the offer. It is not an valid compliance in the eyes of Indian court of law, because here you have to pressure the offeree to accept the offer. It is not valid in the eyes of law. Second thing, you have to listen. Acceptance, it has been defined under section 2 subsection section 2 subsection B of the Indian Contract Act 1872. Definition: when the person to whom the proposal is made. That is, when the person to whom the proposal is made. That is, when the person means when offerer has given a proposal, or either you can say that offer and proposal both are synonyms with each other. Understand? To the person made signifies his assent thereto, the proposal is said to be accepted. That is, when the offeree has given assent to the offerer that I agree with your offer and I agree to do that thing which has been mentioned in the offer. I agree with that thing, then in the case it is valid acceptance. There are also certain characteristics, or either you can say essentials of a valid acceptance. Acceptance must be communicated. When in the same way, when we have talked about offer, validity of an offer, essential of a valid offer, then you have to talk about a offer must be communicated. In the same way, acceptance must be communicated, must be unconditional. That is, an offer can be conditional, but when we have talked about acceptance, then it cannot be an unconditional, because that a unconditional of acceptance, it will be treated as an counter offer. And counter offer, when a person has gives a counter offer, there in such case original offer has lapsed and another offer has arisen. Therefore original contract has become discharged with the help of conditional acceptance. Therefore an offer can be conditional, but when we have talked about acceptance, there in such case acceptance cannot be conditional. That is, acceptance must be unconditional by a specific person. That is when we have talked about acceptance, there in such case acceptance, when we have to give an offer to a specific person, to a particular person, or to a particular group of person, there in such case an acceptance can be given only by the specific person or a particular or a group of particular person. If any stranger has given the acceptance, there in such case it will not treated as a valid acceptance, it will become an discharge offer. Must be within a specified or reasonable time. That is, when an offerer has mentioned the specified or time limit for the given of acceptance, then in such case an acceptance must be given within a specified time limit. But when offeree fails to give an acceptance within a specified time limit, there in such case offer become discharged. Understand? Therefore you have entitled liable to give an acceptance within a specified time limit. But when you have to happy with and think that there is no mention about the time limit, there in such case there has an also certain restriction that an acceptance must be given within a reasonable time. What is reasonable time? Is now we are defined in particular circumstances of the particular case. An acceptance can be expressed or implied. When we are talking about an offer can be expressed or it can also be implied. In the same way, acceptance can also be expressed or implied. That is, acceptance can also be given by the orally, by the written manner, but an acceptance or an acceptance can also be given by the same by the other than written or orally manner. Acceptance should be prescribed mode of communication. That is, when an offerer has prescribed the mode of given acceptance in an offer, there in such case an offer must be there in such case an acceptance must be given within a specified mode of communication. If offeree fails to give an acceptance within the specified mode of communication, there in such case offerer has entitled to reject the offer. But if he has otherwise he has unless he has agreed, then in such case it will be valid of acceptance. Communication of offer and acceptance and revocation of offer and acceptance. Communication of offer is complete when it comes to the knowledge of the offeree. Understand? When offeree has comes to knowledge that offers about the offer, then communication of offer is complete against the offeree. Communication of acceptance is complete in the two cases, and against offerer and against offeree. When offeree puts the acceptance in a course of transmission and it is beyond his reach is to stop it, then it has complete against offerer. And when the acceptance comes to the knowledge of the offerer, it is completed against the offeree. Revocation of offer is valid before offeree puts the acceptance in course of transmission and it out of the reach of the stop it. Revocation of acceptance is valid before acceptance comes to the knowledge of the offerer. That is, an acceptance can be revoked only before the acceptance comes to the knowledge of the offerer. If you want to revoke the offer, then there is a duty of offerer to revoke the acceptance before the acceptance letter has come to the knowledge of the offeree. Types of contracts. There are certain types of contracts, that is, types of contract as per Indian law and types of contract as per English law. Valid contract